Let's talk about how CMS has shown love or maybe not shown love with respect to work comp MSAs, right? So let's dive into our session today. Got a pretty healthy agenda here. We're going to talk about these developments in section 4.2, version 4.2 of the CMS Work Comp MSA reference guide regarding the $0 MSA review and approval submissions, how they differ, how that section differs from the prior version coming from CMS. And then we're going to talk through the new criteria and really the 4 ways that someone can properly conclude, according to CMS, how a $0 work comp MSA may be appropriate depending on the specific facts of the claim. And then at the end of our presentation, we will talk about the solution that we have cooked up to offer the workers' compensation community with respect to how to address this issue. Because if CMS review and approval of your zero is no longer an option, the question that comes up to me front and center is, how comfortable are you going to be with handling this issue on your own? How reliant are you going to be? How determined are you going to be? How sure are you going to be about your conclusion? And relying on that going forward, in lieu of CMS possibly denying benefits to the injured worker post-settlement, or paying certain bills and then chasing a responsible party for those bills. So we're going to cover that lay of the land. We're going to take questions and answers as we go, as well as have the time at the end of our session today to answer those. So if you're interested in getting a question in, feel free, go ahead and put it in the Q&A. And let's go ahead and get started with, Raphael, what is a very simple, basic, but perhaps misunderstood proposition, even after a generation, right?
It really is, John. And as we go along here, there may be those inconsistencies, will be pronounced, if you will. But the concepts, at least for today, still through today, are still the same, right? That the production of a workers' compensation Medicare set-aside and the submission of that product over to CMS, both of those things remained a voluntary act. There is no statutory requirement. There is no regulatory provision that requires that. That remains, even throughout this discussion and these new changes that we're talking about, it remains a non-requirement, a voluntary act.
Of course, that's true in, approximately 48 states. There are a couple whose work comp commissions do require submission when it meets Medicare's voluntary review thresholds. Will be interesting to watch as we go forward how those 2 states react to this policy change from CMS.
Great observation, because we do have, although not statutory requirements, they are internal judicial rules, if you will, to the process of approving a workers' compensation settlement to that specific state jurisdiction. I think you're absolutely right. This issue is now going to come where we have historically been used to going to CMS and getting zeros approved to be able to show our commissions and our judges that CMS has okayed this process. Without that now, what will these specific jurisdictions do in regard to that? So great observation.
So even though not required, we know that CMS takes the position, broadly speaking, that their interests have to always be considered when resolving a workers' compensation claim, right? Jim, 45 plus years representing employers and carriers within the Mississippi workers' compensation system. Talk us through for a couple minutes about the advice you would give to your clients when confronted with this MSA issue. And did that change over time?
Well, I think that it did. When we first became exposed to the fact that the law was in existence and needed to be adhered to, we would talk about it, and many were just of the opinion that it just didn't apply to them. They weren't going to pay any attention to it. And for several years, there was not much attention at all given to the details of compliance with the MSP law. it finally started to catch on that there had to be something done. And as you know, there was a flurry of activity by a number of vendors at the outset, trying to offer all kinds of different products to address these issues. But many of the lawyers just, particularly if it was below the workload thresholds, they just said, well, we'll just pretend that we're in a safe harbor here and just not have to worry about it at all. So it took some time to get everybody on the same page to recognize that that was not the law. It's not. It is not the fact that it's below a workload threshold. That doesn't mean it is a safe harbor, and you don't have to worry about this. And so most everybody that I work with began to recognize the significance of this and had their partners in place to try to get it set up properly so that it was done correctly. The zero MSA was something that we used when the circumstances were present for it. Cases that were denied, as an example, and there was no calculation of specifically anything related to indemnity or medical or other expenses that weren't covered by Medicare. And so most of the time we were able to get those put together and they could be processed appropriately as a zero. That got to be harder and harder, as you know. One of the biggest problems that we ran into, of course, was that after we got the zero and then got it approved by CMS, and then we got the claim settled and approved by the Mississippi Commission, well, immediately the conditional payments started coming in after that. Because you may not have owed anything in the future, but once you settled the claim, you became obligated to deal with the conditional payments thereafter. So that was another challenge that we had.
Raphael, Jim spoke to the confusion that has been around this issue for now more than 20 years. You have been deep in it since the very beginning, right? Since 2001 and before that, the Patel memo, first inkling from CMS about work comp MSAs. You have experience working with a few vendors in the MSA industry. Talk through a little bit your background and experience in the types of solutions that maybe were being offered back then, and where those, how that might have changed between 20 years ago and what's happening in today's world.
John, as you will know, right at the very onset of this process, it truly was a medically based review, medical records reviewed, looking at what those future needs would be or not, and trying to document through that lens, right, and provide CMS an analysis of that particular picture. As I think practitioners, employers, carriers, claimant representatives began to experiment, learn from, and ultimately feel a little more comfortable with this process, everybody began to ask Medicare to expand, sort of, wait a second, not all of the facts, not all of the cases, not all of the issues fit within these small parameters that maybe CMS had created. And sure enough, right, that's where the $0 workers' comp MSA ask for review began as. Clearly, if you had documentation that the claimant was no longer in need of future medical services related to this particular claim, that was medical evidence sufficient to be able to submit that to CMS. But what if there was some other cause for that now no longer needing? What if there was another issue engaged? What if there was an originally compensable claim, but it got denied later on? And so the beginnings, John, if you will, of a legal aspect to this $0 workers' comp MSA. Certainly along the way, when folks began to decide not to submit these workers' comp MSAs to CMS for review, right, and start to use medical guidelines or other type of instances to be able to produce a workers' comp MSA but not submit it, that also became a component of this equation, which I think to some degree is addressed, right, in this new policy that CMS has created. So it has evolved, definitely, as you will know.
So let's go ahead and talk through what these changes are. And to start, let's see where we have been most recently from CMS. So this is going back to version 4.1 of Medicare's reference guide, which came out last year in 2024, where it said that under the following conditions, work comp MSAs not necessary, right? Facts of the case demonstrating that the injured individual is only being compensated for past medicals, not future medical care. There's no evidence that the individual attempts to maximize the other aspects of the settlement to Medicare's detriment. So burden shifting, right? Treating physicians concluding that the individual will no longer require any Medicare covered treatment related to the work comp injury. That word related for me is one filled with ambiguity when it comes to this issue and the Medicare Secondary Payer Act, period. And then the settlement leaving the employer, insurance carrier with the responsibility for ongoing medical and prescription coverage. The combination there all leading one to what I think is a pretty natural conclusion that, hey, a $0 here is appropriate when these conditions are being met. But if we're being honest with everybody, how often do we see a workers' compensation claim that's fitting nice and neatly into all these various boxes, right, guys?
That's absolutely,
They're all different.
yeah, that's absolutely right, John. So those of us who've been engaged in this process for a long time and who have had conversations with the CMS MSP team leadership had been asking for years, right? Provide us with detail, right? Information about what exactly do the parties have to do down here on the ground to be able to protect Medicare's future interest when, there may be a legal situation that warrants a zero. And so these four that you see here in front of you, these are the things that CMS gave us over a 20+ year period, one of them at a time, as we continued to beg and plead for more exactness on what exactly, from CMS's perspective, would warrant not having to do a workers' comp MSA or a zero workers' comp MSA. And so these are, I think, the limited things that CMS had provided to us over many, many years, right prior to this latest provision. And as you can see, and John, I think you hit it right on. Not all of our cases fit these four boxes. Not all of the facts and issues that we work with every day fit neatly into these different components. So a lot of us still had to submit that zero MSA to CMS to try and figure out, is this appropriate? Is this the right analysis? Are we doing right by you, Medicare?
Yeah, and the option was always available, right? And CMS was willing, if it met the voluntary review threshold, CMS was willing for the WCRC to start that process. And typically, when we're talking about obtaining a $0 MSA approved based on legal rationale, we know that's not a WCRC component that would get kicked out to regional office for them to review and approve. But it's because we had this lack of clarity, guidance, and a realistic policy position enumerated, verbalized within the reference guide that the workers' compensation community could really rely on, that the intention of trying to get a $0 MSA approved by CMS, it kind of became the industry standard, didn't it?
It did. Jim, having had that lengthy experience with employers and carriers, did there come a point in time where you yourself, as advocate for your clients, feel comfortable with what CMS, what had put out as policy or guidance in as far as when a zero workers' comp MSA was appropriate or not appropriate? Was there ever a comfortable time in that regard?
Not in my recollection and not in my experience. There were some who were willing to try. There were others who were not willing to do so. I think there were probably many who just wanted to take the chance and not worry about it, and think they were so small out of so many cases that it probably never would be found, which was not a good path. Obviously, we did have cases where trying to get a zero MSA was absolutely the path, the plan, and the effort. I can't say that it became commonplace. You know, just one of those things that wasn't done every single day, in my experience, in my practice.
Jim, you mentioned something very interesting right there to me, and that is that sometimes the cases you were involved in, your clients or the parties to that claim agreed that they were willing to take the chance, not submit, right? And if Medicare does something adverse down the road, they do something adverse down the road, you'll deal with it then, as opposed to being proactive. It's worth pointing out, we're going off script a little bit, guys, okay? That it warrants this point to be made. There's no longer going to be the option to take the chance, so to speak, at least with respect to current Medicare beneficiaries, because we get, starting April of this year, mandatory MSA data reporting via the TPOC report through MMSCA Section 111 mandatory insurer reporting. So that's something that everyone needs to understand is layered on top of this development, is that Medicare is going to be knowing about the MSA details regardless, because it has to be submitted as part of that data report.
Exactly right.
Really interesting, John, because the combination of both of these, right? Allowing now folks to do whatever it is that they think ought to be done regarding these zeros, but then further the ultimate reporting of that conclusion over to CMS. The combination of that will have, I think, ramifications for a lot of folks out there who may either not understood the policy or who have been experimenting with that policy to some degree. Now, that actual reporting of your conclusion of a zero, it's going to mean something. It's going to have an action and reaction over at CMS. It will most definitely be part of that common working file, and therefore, it will be a component of the furthering of this equation over at CMS to conclude whether I'm going to pay or not pay, whether I seek reimbursement or not. So this new process that I think at first glance may say, well, great, I'm in power now, but it must be reported to CMS with now consequences to that effect.
And one of the points that is continued as we're about to look at the new developments in version 4.2 is Medicare's continued statements about, absent CMS approval, Medicare can deny future medical payments on behalf of the beneficiary, or can pay certain bills and then seek reimbursement from beneficiaries, attorneys representing beneficiaries, providers, employers, carriers, self-insureds, etc. Right? So there will remain this uneasiness, this disconnect, this gap, I think, going forward that needs to be filled with respect to something out there that's going to provide the assurances to the parties resolving the workers' compensation claim. So here we go into version 4.2, section 4.2. I don't know if that was intentional by CMS or not. Regardless, this came out January 17th of this year. And where Medicare announced starting July 17th of 2025, Medicare will no longer review and approve $0 MSAs. And essentially, the parties resolving the work comp settlement are going to be self-policing. They're going to utilize $0 when it's appropriate based on how CMS has issued the criteria in this updated guide. So, Raphael, walk us through these criteria, if you would, because there's some are somewhat similar to what Medicare has said, verbalized in the past, but now we've got some additional complexities to this if we dig in.
We do, John. So this first one, it was already in the books, if you will. 4.1 already had it there. This is our longest standing policy at CMS of when a zero workers' comp MSA would be permissible. And that's, of course, if we have a treating physician who documents medically within a reasonable degree of medical probability that the claimant no longer needs further medical care associated with this particular date of accident and the injuries associated with this accident. That, as you've indicated, John, it's been around the block for a while. We have all known that this is sort of the basic reason why a zero would be permitted under the CMS guidance or theory. So nothing new here, other than we have to make sure we put an accent on, those words, treating physician. So the idea of an IME, the idea of possibly a second opinion, right? Again, not very well looked favorably upon by CMS. They want to hear from the treating physician, that doctor, that physician who has been on an ongoing basis, been providing medical care to this injured worker, right? They now want make sure that it is in writing, to make sure that it is well documented, right? And I think the clarity, right, that there is within medical certainty, no longer the need for this future medical related to the claim. I think all of those are magic points, if you will, right? That from now on, you've got to make sure you've got it from the treater, from the treating physician, that you've got it in writing, and that there is those magic words, if you will, that within a medical degree of certainty here, there is no longer any need for further medical care.
Ralph, one of the problems that I see with the way that is worded is that the reality is most litigated workers' compensation cases do not have a single treating physician. There are multiple physicians who get involved, either from an examination standpoint, on referral from the first doctor, or sometimes a referral from the second doctor. And so when the concept is it's got to be the treating physician making this statement, no further treatment, they're not recognizing the reality of the workers' compensation process itself and how difficult it can be sometimes with multiple body parts involved and therefore multiple physicians who would be involved. I think it just is another reflection of how little CMS has taken workers' compensation law into consideration in characterizing its rules here.
Well, and guys, it's one thing to say, hey, it has to come from the treating physician. Nobody else. No IMEs are good enough. No secondary physicians are good enough. It has to be from the injured worker's treating physician. For me, the biggest part about this statement is that that opinion has to be rendered to a reasonable degree of medical certainty. Listen, Jim, 45 plus years practicing work comp defense. Raphael, been in the industry since it was born. How many times have you guys been able to obtain that type of documentation to this CMS standard?
Very rarely. Very rare. Doctor says, look, I don't have a magic wand where I can wave over this picture and know exactly what's going to happen. Most of the time, there's not any treatment or not much treatment. But to say that never need any more treatment at all, I'm just putting myself out there, and I'm not willing to do that.
Are we going to see a lot less zeros now? Because that is the standard, that is the burden, right? Or, will the doctor feel comfortable? MMI, 0%. We always, when we take the doctor's depot, have asked, doctor, has all of your testimony here today been within a reasonable medical degree of certainty? And most doctors are comfortable answering that question in its generality. But John, you've added that extra layer specific to this issue that we're talking about. Jim, as you've indicated, with regard to future medical needs, right? That's a big gulp, right, if you will,
Yeah.
Because who in the world knows what this thing is going to look like a year from now or 5 years from now, right? What that impairment may look like. So it really is, when we start diving into the substance, the minutia of these new requirements, it is something to stop and really think about, whether we're getting the right information to be able to then move to the next step here.
So if that is a high bar to have to attain, maybe we need to look at criteria number 2, because maybe our case can qualify here as far as, hey, the claim was denied and no payments were ever made by the employer carrier.
You got it, right? So that first one, we've had in our pockets for a while. It has been part of the CMS solution-driven mechanism for a zero workers' comp MSA for a while. This is the type of thing that we had been begging and pleading for many, many years. Brand new, right, to us. So this is completely new as of January here of this year, as part of the policy of when that zero would be appropriate. And John, you hit it right on. The claim has been denied by the employer if self-insured or by its carrier if insured. No payments, right, having been made by that employer and carrier, no indemnity benefits, no medical care, right? And we know that when we did submit a zero workers' comp MSA to CMS, as part of that submission process, they wanted payouts of indemnity, of medical, of expenses, because sometimes we all learned that there were either indemnity or medical benefits in that expense payout. So Medicare got more and more aggressive about wanting proof that, in fact, this case had been denied and that no payments had been made, right? So, John, immediately when I saw this particular policy as new here, like, okay, we've lived under this theory all these years. We know what CMS has requested of us before. Should we duplicate that same scenario, that same request of our clients to make sure that we can, in our own files now, document, right, the payouts that show zero, that shows, you know, a first report of injury and a notice of denial that goes along with it?
For me, guys, this makes common sense to me. This is logical. This is, hey, the employer carrier never accepted responsibility for medicals pursuant to the statute. They're not paying a dime for indemnity for medical. Maybe they paid some dollars up front while they were investigating the claim. So if you're in a state that has payment without prejudice provisions built within the workers' compensation statute, this is going to be a viable option for you as far as that goes. But this is one that I can see being out of the four choices, one that's fairly popular to look to and try to get your facts to adhere to this particular selection.
I totally agree with your analysis there, John. One of the things, and I want to alert folks, you know, that are here with us today, that very last bullet point here, that the settlement agreement doesn't allocate certain amounts for future or past medical or pharmacy needs, right? Because we have seen that zero allocation, but yet the settlement agreement allocates certain numbers of dollars to these things. And that's been a no-no. And they've now made it very clear, right? Denied, no payments, and making sure that the settlement is consistent with those allegations and those facts, that there is no allocation for medicals and pharmacy as well. So I agree, John. I think this may become, you know, feasible, more popular, more doable for folks who are still seeking a zero workers' comp MSA, making sure that they've got the evidence. Yeah.
Well, yeah, I tell you what, over the years, how many cases have we been asked to look at before the advent of this new policy, right? But we're looking at it to see, hey, is an MSA necessary, yes or no? And if so, what's the right dollar amount to fund it in order to comply with the Medicare Secondary Payer Act? And we're going down and we're looking at, okay, criteria 1, check. Criteria 2, check. Criteria 3, check. We get to the fourth one about the settlement agreement. We're given the agreement and we say, oh no, they've already done it. It's signed. They agreed to a certain allocation. It really destroys the argument and ability to hang your hat on this selection going forward. So your release language, your clincher language, vitally important as part of the process. It's not going to be enough that the facts line up. Your clincher agreement is going to have to be pristine with respect to the actual words and how you are constructing your agreement going forward, if you want this $0 MSA to be an option that you can rely on.
Good call out, John. I totally agree.
Third potential option. Let's get the courts involved, right? So judicial rulings and no current payments. Similar, but slightly different, right, Raphael?
Absolutely, John. So here, maybe this case began as a compensable claim and benefits were paid. And somewhere along the line, right, the medical opinions, the medical evidence, the issues and facts in the case changed. And now there is a denial, right? And now you take that issue and there is a disagreement with that denial, and you take that issue to your fact finder, a workers' compensation judge, a commission, a board, right? Whatever the tribunal court that makes those decisions in your state jurisdiction. And there is now a finding that that condition is not related to this claim, not causally connected to the accident, to the injuries associated. And so that is the thought here, that perhaps even though born originally as a compensable claim, that if there is a judicial finding later on that there is no longer that causation factor here, and that it no longer is the employer carrier's responsibility, in those situations, a zero workers' comp MSA would be appropriate as well. Note that the same requirements we talked about on that last one, John, are also part of this one, meaning no ongoing benefits paid, and the settlement agreement must be consistent with that argument that we're making here, as you've already indicated. Again, this is brand new to us. This is something that a lot of us have been begging and pleading for a number of years. And it's good to see that CMS had been listening. CMS had in fact taken note that this is a request of practitioners and the professionals that work in this specific area, that we wanted a provision that talked about the judicial decision of when a claim is in fact denied by the court.
And Raphael, this demonstrates and shows the tremendous growth within CMS and the group there overseeing the program here for Medicare secondary payer, right? 20 years ago, as you said, it's all medical. We just want to look at medical records. We now have the linkage to the judiciary, to what's going on in the court system as it applies to the case. Jim, how many cases were you a part of in your career where originally accepted, your client was paying benefits, but the case was positioned and later a judicial ruling to this effect was obtained?
Well, that happened quite frequently. And I was just thinking through what the scenario usually was. Let's say you started off with a back injury. Claim was accepted as compensable, benefits paid, and then they started complaining about their leg, which was allegedly also injured in that same accident. And the litigation surrounded whether or not they owed for the leg. There might be a finding that the leg complaints are not causally related to the accident of whatever date, but the order may still also say that the employer and carrier are otherwise responsible for the necessary and reasonable medical, such as the nature of injury and process of recovery will require for the compensable body parts. So just because you beat one body part doesn't mean that it's going to be an order that says you don't owe for any other medical or anything. I've never gotten an order like that, unless the claim was completely denied in its entirety, and that denial was sustained in the litigation.
Good point, Jim. Good point, because that right there is the general experience in comp. There may be an extra or new body part or impairment that may get denied, but the original one, which was accepted, remains open. In that situation, a zero workers' comp MSA wouldn't be the case, wouldn't be appropriate, unless, of course, you had medical evidence that the claimant no longer needs medical care with regard to that injury. But so you're absolutely right. Just because you win on this one doesn't mean you still, are allowed to have that zero workers' comp MSA. Good point.
So in that scenario, guys, let's for the audience, let's take that one step further. So we get that ruling with respect to that one body part of condition, but everything else is still compensable. Obviously, the zero for what the court has ruled on is appropriate, but for everything else, a zero is not appropriate. We still need to worry about future. We need to calculate what that looks like and be funding something appropriate for those other compensable body parts and conditions.
You got it.
Perfect. Let's move on to the fourth criteria, the fourth way that one could safely fund an MSA for $0. And that has to do, and there's some duplication here with number 2, I think, Raphael, but this stands on its own merits here, and that is where there's been a denial within the pay and investigatory period of time on the claim, right?
You got it. So this wasn't always the case. This is fairly new in the grand scheme of workers' compensation statutory provisions, right? We've seen over the last 20 or so years where statutory amendments to the workers' comp laws around the different states in the country, allowing for this provision of go ahead and pay the claim. We're not going to hold it against you. We're going to give you 30, 60, 90, 120 days to investigate the issues, the facts, the connectivity. And at the end of that time period, whatever the statutory period is, then, right, there has to be a conclusionary point where you say claim compensable and accepted, or claim denied and no further indemnity or medical benefits paid. If in fact you have that kind of a situation where it looks like a compensable claim, the payout shows monetary benefits and medical care benefits provided, so it would otherwise indicate a 0 not permissible unless you've got a judicial finding or medical that says no further care. They have constructed this exception that if in fact properly denied within that pay and investigate period, even though original benefits paid, it will not disallow the 0 workers' comp MSA. So you're right, it is a part of number 2, but they've isolated it here to make sure that it's clear to everybody that that is a permissible workers' comp MSA, 0 workers' comp MSA, given the right facts as indicated here.
So guys, question coming in from the audience. We'll go ahead and fill this in real time because it's right on point with this 4th criteria. Questioning coming in from a comp practitioner in the Commonwealth of Virginia. So how long can they pay and still be considered by investigation, as there is no statutory period in Virginia? Does this have to adhere to a state workers' compensation statutory period, or is this more open-ended than that?
No, so this is clearly isolated to those states that do in fact have a pay and investigate provision in their state workers' compensation statutory scheme, right? In states where they do not have one, if you begin to pay and it's a compensable claim, then you're going to have some sort of decision by the board, the commission, the workers' comp judge that indicates no longer compensable, no longer, right, allowed indemnity or medical benefits associated with it. So this provision very specific to those states that do have a pay and investigate component to their statute. And therefore you're guided by whatever that statute says. Some states allow 60, 90, 120 days of pay and investigate, and then a termination of that provision, meaning that's it. If you pay beyond that, it's a compensable claim. You've got to stop and make a decision at the end of that. Otherwise, it's considered a compensable claim.
Yep. So this criteria not applicable in all states, but if your state does have payment without prejudice provisions built into the workers' compensation statute, this is one to pay attention to, one that may be appropriate. Okay. Tell you what, before we transition into our solution to this development, let's take a couple more questions from the audience. Let me go back one slide to our judicial rulings and no current payments. And the question coming in asks this: does the decision of the commission have to be final before CMS will acknowledge the exoneration, or can we settle after an arbitrator or an administrative law judge has made the decision and the decision is still subject to appeal? Good question.
Great question. And we have lived through those issues and those facts when we were able to submit these zero MSAs to CMS. And from a historical perspective, the answer there is CMS says it must be final. If that decision is not yet written or it hasn't been signed, or if there's still a time within which, right, the parties can appeal, that is a non-final order and therefore no go yet, right? That denial must be in fact sort of the law of the case in order for it then to become the basic component of this request for a zero. At least from a historical perspective, John, that had been the road that we had all learned from CMS by, again, challenging and trying and forcing CMS. And we learned that the hard way. I'm thinking that experience, right, we will benefit from that here as we provide legal counsel to clients to say, if in fact this decision is not yet final and it can be appealed, we're going to have to let that time period run before we can then formalize the next process, right, to truly create that zero workers' comp MSA.
Another question coming in. Jim, when you were representing employers and carriers, did you ever have an employer claiming fraud? Claim initially accepted by the employer carrier, but along the way, the employer claims fraud, which in the state of Louisiana would completely end benefits. Can you use a zero MSA at that point? Or do we need some additional steps to be taken in order for the zero to be valid? What do you think, guys?
I think that just because the employer takes a position on that doesn't mean that that's the only answer to the question. I think they'd have to prove the fraud and have the effect of that fraud enacted through the order of the commission or judge or whichever it was. But I'm just claiming fraud as a defense is not going to be enough in and of itself to say, okay, this is over and done. This is all we have to worry about.
Yeah, I would think you need that judicial ruling to agree with that allegation, right?
Yeah.
To fit into one of the criteria.
Yeah. And again, I think this also illustrates a side point that makes me not sure that the CMS quite understands workers' compensation. You know, all the state laws are different on different points. And just because the employer says this is now fraud, as an example, in this particular case, what does the carrier say? Under some state laws, the employer doesn't have a voice in whether or not the claim is paid. It's all left up to the carrier there. So the employer's position wouldn't make any difference at all, unless you got an order saying, well, this claim is being shut down and denied fully because of the fraud that was proven. So it's again, trying to apply a big Band-Aid to a very complicated moving system out there. It makes it so difficult.
Yep. Raphael, any additional thoughts there?
You called it, John. I think that's the kind of situation where you're going to need a judicial order agreeing that it is fraud and therefore no benefits further due to be able to take advantage of this zero workers' comp MSA. But it brings a great issue to the forefront, John, which is variations of these fact patterns, right? Where maybe historically we had the opportunity to present that component to CMS and get their opinion on it. That's now gone, right? So folks out there, just like that question, are going to be met with the situations and you know, you're going to have to be able to start building, right, these processes in order to say when can you and when can you not. In that particular situation, and I agree with Jim, just because you believe or you have evidence of fraud doesn't mean that it is. You're going to have to take it to the next level and document that through a judicial order or finding.
And that's going to be one of the key takeaways from this session for everybody who's watching this, whether it's live or after the fact, okay? The law matters. Your state workers' compensation law finally matters to CMS. That's why we're getting these potential solutions provided about $0 MSAs, is that you need to be able to take the facts of your case or claim, apply it to your state workers' compensation statute, and then overlay that with the Medicare Secondary Payer Act, the statute, regulations, and administrative guidance, specifically Section 4.2 of this Work Comp MSA reference guide in the new $0 MSA policy, to be able to come to a conclusion as to whether a $0 MSA is appropriate or not, and ultimately, is it defendable or not if push comes to shove down the road. So, guys, natural transition. We've got about 10 minutes left in the 60-minute session. We're going to stay overtime, I feel certain, fielding questions and answers. There's a ton of questions to get to. But for those of folks out there who are limited to 60 minutes, I want to respect that. So I want to go ahead and get to the end of the presentation. And then if folks want to stay for the Q&A, happy to. We're going to work through all the questions here. And just so everybody knows and understands, we are going to make the slides available. We will email them out to you after our session is done. I'm sure we'll also put them out on our LinkedIn site for folks to download. And we'll make this presentation available on our firm's YouTube channel as well. Okay, so plenty of opportunities for you to go back, revisit this. Think about how this new policy applies to your cases or claims, and then fit in how that works within the criteria, as well as maybe the solution that we're bringing to the workers' compensation community for this issue. It's an old solution that our firm has always offered, but it really does have new relevance given this $0 work comp MSA development, right, guys?
Absolutely right, John. Right. The ideology here, for folks who have known us as a firm for a long time, that theory still very much the same, right? We're going to analyze, we're going to look at evidence, we're going to study situations, we're going to look at statutes, we're going to look at case law, we're going to look at all of the different components to then be able to give you what I think is a solid legal opinion about, and very specific here, whether a $0 workers' comp MSA is appropriate, considering all the facts and the situations before us.
For the longest time, I think the industry has, in a way, had this codependent relationship with CMS when it comes to the notion of a legal zero, right? The industry knew, hey, we've got the ability, if it fits into the voluntary review thresholds, we can ask Medicare to approve our zero. And CMS, even though they really probably squirmed at the notion and thought of having to approve a zero, were presented zeros fairly regularly and understood that the work comp industry really relied on them to stamp their zero or say, you know what, this is out of bounds. You really need to fund something for X here, okay? With that going away, there really is a need and I think a desire out there for sound, competent advice that allows parties to paper their files with the fact that they've considered Medicare's interest with respect to this issue, to be able to incorporate a legal opinion like ours as an exhibit to their clincher agreement for submission and approval from their state workers' compensation commission. And ultimately, at the end of the day, as lawyers in a law firm that are giving legal advice about these issues, really standing behind what we're doing, the advice we're giving, and just like any other area of the law, lawyers providing legal advice, clients have a right to rely on that legal advice, and if they do to their detriment, they obviously have recourse. So we are in a position where we're going to stand behind our conclusions. And down the road, if something happens, if benefits are getting denied, if Medicare has paid bills and is seeking recovery of those bills, it's going to be a powerful thing for a client of Caddy Gonzalez to have a legal opinion in their file at the end of the day. It's something, guys, we talk about with some regularity around here, and that's this notion of the Caddy Gonzalez promise, right?
It is.
Absolutely. Absolutely.
We have been using this theory, if you will. And John, it's been tested in the federal courts, right? The theories that we put forth have been around now for a number of years, right? And it attached to that is this promise from our firm that if something detrimental happens and you're relying on that opinion, that we will stand up and we will defend it. We will take it to an administrative law judge. We will take it to appeals councils. We will take it wherever it needs to be so that the basis of that opinion becomes paramount to where and why that conclusion was reached. And so that we've been doing it for a long time. It continues to be done now in this new arena where we are truly on our own, if you will, to make sure that we're doing right by CMS, to make sure, and especially, John, after April 4th, as you've already indicated, where that zero will have to be communicated to CMS, right? Where maybe historically on the lower valued files, Medicare has run blind, if you will, not knowing what parties have done to take Medicare's future interest. Now, even on those cases less than $25,000, or if not on Medicare, it may be, even on those files, Medicare will know, right, the value of this allocations, and it's very specific to the zero we're talking about here.
Medicare lawyers giving legal advice about Medicare laws. That's what this is at the end of the day. When I started this firm in 2016, it was on the backs and shoulders of working for a vendor for almost 10 years prior. And the conversation that I routinely entered into with clients and customers back then was, now, is this legal advice that you're giving me? Because you're a lawyer, but you're not a law firm, right? No, I'm a lawyer who's working for a corporation. So what I'm giving you is not legal advice. Okay, it's advice based on experience and knowledge, but it's not legal advice that you can rely on. We are not in an attorney-client relationship right now. Okay, and I constantly heard, well, I wish I could rely on your legal advice for this issue, because that's stronger at the end of the day than what you're being able to provide me. And I really took that to heart. So when I opened the firm in 2016, really making that a central focal point of what the firm has been doing since day one. And that is giving clients legal advice about how to handle Medicare set-asides and future medical obligations under the Medicare Secondary Payer Act. With this $0 MSA development from CMS, announcement and new policy starting July of this year, we're able to take that to the next level, because we're able to help more clients by working with them in an attorney-client relationship, giving legal advice about these issues that they can rely on going forward. And I know that for a large segment of the population, they'd rather be working with lawyers giving legal advice about these issues as opposed to vendors who cannot give that same type of legal advice at that same high standard.
That's a very strong point, John, and one that I agree with. When I was in private practice, I did rely on the advice that I could get from y'all on cases. The legal opinion just works very well for the circumstances, particularly when many of the cases are not, the settlements are not even within the workload thresholds that are established by CMS, and you have no other way to deal with those cases. You can't get them to say yes or no. It's outside their thresholds. So it's one of those things that proved to be very valuable in my practice. But one of the things that I always have to point out is that even if we do get a zero MSA approved, people still have to worry about the additional payments that come in on the backside. So it's not a way to get a zero to walk off. The dealing with the additional payments, of course, is a separate step and a separate process that we can help with as well. So,
yep. And Jim, as we know, that involves both Medicare conditional payment recovery contractors, the CRC and the BCRC, in a comp claim that's been denied in part or in full. And then to layer on top of that, the mandatory reporting obligations that are here, the civil monetary penalties that are beginning to accumulate internally at CMS for certain non-compliant parties, the new MSA data points that have to be reported to Medicare starting in April. The MSA question is one small part. It's an important part, but it's just one small part of a settlement that is fully MSP compliant, Medicare Secondary Payer compliant at the end of the day. So guys, as promised, listen, Ralph, don't let Alex, your son, ever tell you that you're long-winded. We are done 1 minute before the end of 60 minutes here. Okay.
I love it, John. Yeah, yeah. I may have been accused once or twice, right?
Wrongfully accused,
So,
you meant to say.
Thank you, Jim. Thank you.
so we are sensitive to the participants' time commitments, and if you have to drop off now, thank you very much for joining us. If you have any questions afterwards, please reach out. There's our contact information. Happy to address any questions, thoughts, concerns that you have. But if you can stay, I see 14 questions currently in the queue. If you've got questions and you've got the time to stay for a few more minutes, we intend to answer every one of these questions. Okay. So guys, why don't we dive into the Q&A portion of the presentation here? And I'm going to scroll back up to the very top and we'll go from here. All right, here we go, guys. First substantive question. What if you have an accepted claim under the Medicare review threshold for a non-beneficiary with an MMI release from treating doctor, but not an opinion stating no further work-related treatment? Can you safely proceed with $0 MSA? And maybe the key word there is safely.
So we've got a non-Medicare beneficiary, John, right? So that's a huge component of this equation. We know we've got to take Medicare's interest in all cases, but this is an individual, and I'm going to assume here, not 65 years old or older, and somebody who has not applied for Social Security disability benefits, and therefore there's no reasonable anticipation of this individual becoming a Medicare beneficiary within the next 30 months, right? So if that's the case, right, we still got to take Medicare's interest. What will be the triggering mechanisms for that zero, right? And we're going to go through those 4 exercises that we've already talked about here today, whether, originally denied and no payments, whether pay and investigate type situation, whether we have a judicial finding, right? That will be, I think, the basis, right, for legal opinions on this. Whether in this particular situation, now that you've got an MMI, but no opinion indicating further related treatment, right? That's, I think, going to be where the focus in this particular situation will be at, is can a doctor indicate, maybe he hasn't been asked, will somebody ask that question? Because if the answer to that is yes, there is still foreseeable care, pain management once in a blue moon, maybe a little pain medication, maybe a visit with an ortho, right? That $0 MSA no longer becomes, right, like you indicated, comfortably. So I think answering that question, and maybe it may take more than, the one question, maybe it takes, a couple of times speaking to the physician about that particular situation.
Jim, how would you feel proceeding based on that without that one additional step that now CMS has verbalized in that first criteria about treating physician, reasonable degree of medical certainty?
Well, the doctor needs to be asked, and I think that under the circumstances of this, we have an MMI, but it's just that the issue of future treatment is not addressed at all. It's got to be asked. You've got to pin that piece down before you know how to proceed on trying to resolve that particular case.
Yep,
got to be pursued.
Agreed with you guys. A 0 may be appropriate. You may be able to proceed with one, but if you're trying to meet this standard from CMS, which I think is a lofty standard, there's additional questions and documentation that needs to be obtained in order to safely proceed with that. So good question. Next question. And this is going to be a question in the context of a longshoreman case. Okay, guys? So coming in from Jeff, with 3 of the 4 qualifying conditions for a 0 MSA requiring no future medical allocation in the settlement agreement, what are your thoughts on how to approach that requirement in a work comp jurisdiction such as LHWCA, right? Longshore Harbor Workers Compensation, which requires a settlement allocation to close out a benefit category?
Well, looking at that At that requirement, as it is written, the agreement does not allocate certain amounts for specific future or past medical or pharmacy services as a condition of settlement. That little last phrase right there suggests to me that there are some who are preparing settlement documents that says we're going to allocate $5,000 for future medical for which Medicare might be responsible. And it's conditioned on being approved, they're getting the approval of this settlement, that's what that's going to be. So I don't think that's the way the settlement agreement should be written to begin with. But there could be a number stated in the settlement document, not necessarily as an agreement, but the evidence suggests that out of this settlement, X dollars, it represents future medical. And again, that's what the Longshoremen Harbor Workers Act requires in their settlement agreement. I think it'd be appropriate to put it in there, but not as a condition of the settlement being approved.
I don't know, Jim, right? My thought when I first read the question, and Jeff, good to see you here. I'm so glad you're a part of this conversation with us. Is that I think settlement documentation better indicate, that there are no dollars being allocated towards future medical, right? There has to be some clarity of a recognition that that is one of the buckets in which claimant, is entitled to or eligible for benefits. And here, this settlement does not incorporate any dollars for that specific, so a whopping zero allocated towards that. That's still a binding settlement. I think it would meet the day with the Longshore Harbor Workers' Compensation Act and the judicial officer who will be signing off on that settlement. To be absolutely clear, because I think a judge may say, why are you allocating zero? And the answer is, in order to make sure that we're living under the new policy at CMS, that's the indicative factor that must be present in order for us to do that here. So the combination of both of those things, I think well documented in a settlement agreement would survive on both ends, the provision of the zero and an approval of the settlement under the Longshore Act.
And that's going to be an interesting development going forward, I think.
Yeah.
Right? Because that's something that hasn't really been seen before, tested before. And now the rubber's going to hit the road. Next question. As to the last slide, on a doctor saying to a reasonable degree of medical certainty that there will not be any future medical is indeed a very high or low bar, because usually most state acts like mine in South Carolina says I can only get the care if a doctor says to a reasonable degree that the injured worker needs it. Anything less, and it is not awardable under our statutes. Therefore, it's kind of a crutch for the injured worker. Not enough to make workers' comp the primary payer, but too much to make Medicare let them off the hook. And more of a comment than a question there, I think, an observation. But again, serves to underline the fact that your state workers' comp statute matters now with respect to this issue. And this is really going to be more state by state than it ever has been before, right, guys?
Totally agree, John. We're going to have to incorporate in our legal opinions, and we do that right now every day, what is that state law? What is that state statute? What is the state regulatory provision say? What do the state case law indicates, right, to be an appropriate wording and mechanism for the doctor's opinion to be a valid opinion for a workers' compensation fact finder? We're going to have to adopt those standards in the bodies of these legal opinions to be able to conclude whether or not the zero work comp MSA that we're talking about here is appropriate. So I think you're absolutely right. Now more than ever, the state law that applies to that particular workers' compensation claim would be incredibly significant here.
Is there any remedy on existing denied cases where the four-part criteria applies, but where CMS has refused to approve the $0 MSA and instead issued an allocation for a standard MSA? So remedies to I suppose what would be a counter hire under today's policy, right?
Right.
Boy, have we talked about that in the past.
Yes, we have. So I'm going to break that question down into these two subparts, right? Because we know that historically, you'd submit that zero, back comes, forget the zero, here comes $250,000 back. We had no appeals mechanism to challenge that. Unless there was a mathematical error, right? Or unless we went back and challenged it, the amended review process, now we're living with that number to settle the file. The good news about this new process is CMS isn't going to second guess our number and provide us with that counter hire here immediately. We're going to have to wait a little further down the line, right, to figure out whether CMS will react to that zero by either denying benefits or making payment and then seeking reimbursement. So it isn't, I think, going to be necessarily the quick fix like we may have had, John, for many years, where we got the answer within 10, 20, 30 days from CMS. We may have to wait a little longer to figure out whether CMS is going to react to that reporting of a zero workers' comp MSA as part of the mandatory insurer reporting process. Nonetheless, I think at the end of the day, the exercise is the same, which is, and now, at least on behalf of that injured individual who is going to challenge the potential denial of benefits or request for reimbursement, we are now going to have a review process where you can have a hearing in front of an ALJ, and we will be able to submit medical evidence, legal indications, maybe testimony from employer carrier and claimant counsel, all of that in front of a fact finder to prove to the court why the zero is the appropriate number.
It's a related question, not asked, but I'm throwing this out to you guys for consideration. Do these new developments, both the $0 effective in July policy and the MSA data reporting effective in April, do either of those developments and deadlines warrant parties to try to either speed up the settlement process in advance of those deadlines, or maybe slow down the process to wait until those deadlines pass? Is there any incentive one way or the other for parties out there that are in the middle of maybe resolving a claim? How does that affect what's going on in real time?
John, I love that question because we're being met with that again and again and again. And the answer very much depends on, the issue in front of you. I can see and have spoken to multiple clients where they want to slow this thing down because they don't have the payout of indemnity and medical and expenses necessary to today convince CMS and give us the zero. So if that is no longer a requirement and only these 4 criteria live without CMS requesting and demanding certain components of things as they had been for many years, maybe best choice for those folks in that particular file is to wait until this new policy comes to play and provide that which is at least visually here required for that zero, and not what CMS has been requesting over a lengthy period of time and adding to all of those requirements. So I think depending on your case, John, slowing it down versus hurrying it up makes sense. That's a good conversation tactically, right, to have with both claimant and defense to be able to come up with an agreed upon way to make sure that Medicare's interest is being considered.
Another timing question, this one coming in from Dean. Dean, thanks for joining us today. Settlement agreement reached in October of 24, contingent upon approval of $0 MSA. Approval was sought in November or December. Development letter received in January. Version 4.2 released. While the parties are seeking the requested documentation, no settlement paperwork has been approved and the response to the DL has not been sent. Claim was entirely denied. $0 paid in indemnity or medical. Is there a reason for Dean to drag his heels a little bit until after July 17?
My thought there is, John, both parties have to talk to each other right?
Mhm.
Maybe agree that because of CMS, if they want to continue to try and provide CMS the necessary documents, right, that are CMS is going to want to approve the zero, let's go do it. If they continue to try that and still no approval from CMS, and we're now past that time where that process is no longer available to us, right? Agreement between the parties that, no longer is it just the zero approved by CMS, but the zero as indicated per CMS's new policy. So I think a good conversation between the parties to be able to come to some agreement to that. Do we want to hurry, let's go get it? Or do we want to answer but not hurry? And if the time is up, then this new process lives and becomes kind of the way in which we're going to have to prove a zero workers' comp MSA.
Next is a comment coming in from California, and do a lot of work with clients out in California. When an employee files a workers' compensation claim, the employer or insurer is required to cover the cost of all medically necessary treatment provided during the investigation period, up to $10,000, right? Even if the claim has not yet been accepted or denied. This provision is mandated by California law, specifically under Senate Bill 899, which has been upheld by the Workers' Compensation Appeals Board. The employer or carrier has 90 days to investigate if a claim is delayed. So California's got that provision on the books. Other states have similar provisions on the books, and that's going to be very important for attendees and participants here to understand what is their state's position, and do they have those provisions built into their statute, right?
John, you've said it more than once here today, and I think it's absolutely true. The state law is going to be very important. And we've known about California's workers' compensation law that it may be one of the only states in the country that has a specific dollar amount attached to that pay and investigate in addition to the time period. So that will become absolutely a component, at least from our perspective, about a legal opinion with regard to a zero workers' comp MSA, meeting the factors enunciated right here. That's part of the workers' compensation law in California. So we've said, you've said it, I've said it. Our state law, right, and the specifics under which that pay and investigate periods are allowed will become very significant from now on.
Finally, the state law matters, right?
Yep.
Right.
So, all right. Is it enough if the state's Workers' Compensation Act states that payment of medical or indemnity is not an admission of liability? What do you think, guys?
I think it should. Again, we're talking about what the individual state laws say and require and provide, and if it's not an admission of liability, it's not an admission of liability. So that would be the argument that we would use in saying that the benefit claim had not been accepted, if that's what the facts actually reveal.
John, we've had some success, right, with this question, and even under old CMS's system of providing proof of this. What helps us tremendously here is case law. If your state has a statute with similar language as here, and we've got case law that even after 2, 3, 4 years of payment, it's not, right, a component of acceptance altogether, right? The more case law I've got to that effect in your state jurisdiction, the better the argument that I have made to CMS, and we have been allowed, right, zero MSAs in that particular situation. So we feel rather comfortable, if you will, very equipped that if we've got a statute that reads like that and case law to that effect in your jurisdiction, right, that it's still appropriate for a zero workers' comp MSA. But you have to have that strong case law that speaks of, years into the case still being allowed to deny it, altogether. So if we've got that,
Absolutely.
success. Yep.
Yep, absolutely. Are there any further resources or guidance on whether your state's laws fit into the pay and investigate provision contemplated by CMS. There's nothing in the guide that directs the reader to other additional resources, but is there anything else out there that someone could look to necessarily?
Larson, you can do an analysis with the Larson's treatise on workers' compensation to see how different states are addressing that, and some don't address it at all, and some do.
Yeah, and I think the policy created by CMS indicates it in its writing, right? If the state law permits it, because CMS does understand that there are lots of states that do not have pay and investigate provisions in the books. And so, you know, could language like that last question we just had, could that be interpreted as a pay and investigate period for more than 120 days, but years in the making? Well, if the case law has been interpreted, you know, to do that, the answer is yes. So in cases and situations where states lack that language, you know, do you have statutory, other statutory provisions or case law interpreting, right, denied authority to be able to do that? I think that's going to become key to this entire component of things as we go along. That, John, as the questions are beginning to tell us, right, and we knew it, this was going to be an area that was going to create a lot of interest and a lot of questions.
I tell you what, if you reside in a state that does not have a payment without prejudice provision within your state workers' comp statute, and you're a lobbyist for the state legislature, expect your phone to start ringing off the hook with people wanting to get those provisions legislated, built into the state law so it fits into this category.
Agreed.
All right. If a carrier pays an initial ER bill or bills, but that's it, then denies the claim in its entirety, would that still qualify as a payment during investigation?
Depend entirely on the specific state that the issue came up, and how their law treats that payment. It certainly sounds as if there'd be a good argument for it, but it will depend on the specific state law.
Yeah. Agreed.
John, again, we've had some success here, right? If in fact those bills were paid and, you know, that was the reasoning, we wanted to be good employers. We want to be good guardians of the system. So we're going to pay while we investigate, even though, you know, our state law doesn't have on the books a provision that indicates that, and within a reasonable amount of time, right? Not a year, but, you know, within days, within a few weeks, that conclusion is reached. We have had success in convincing CMS when we were able to submit them to them for their approval, that met the spirit of that provision that we're talking about here, right? An appropriate way to investigate. If it's not an excessive amount of weeks, if it's not an excessive amount of dollars here that we're talking about, but a truly confined in space, time, and sources here, that has been approved by CMS previously.
Here's a question from Jeff Napolitano from Louisiana, one of the most experienced practitioners down on the Gulf Coast. Jeff, thanks for joining us today. If a claim has been denied from the start with no benefits paid, if a settlement is reached, do you need to allocate the settlement amount between indemnity and medicals?
It's always good to hear from Jeff here, one of our favorite practitioners around the country. So Jeff, based on this new language that they have provided us, right? If the intent here is to allocate $0 out of that settlement for future medicals related, then it is a no-no. We do not want to allocate any of those settlement dollars towards future medicals, right? That is, I think, the direct language, and very much, I think, the hint here, maybe more than a hint, from the language that CMS is providing us in this new policy, that there would be no benefits, no dollars being provided for future medicals in that settlement agreement.
So guys, to take that one step further, because maybe this is a distinction without a difference. Paying out a lump sum is listed within the agreement, right? is there a difference between just listing the lump sum award within the agreement versus listing the lump sum, but then saying out of these proceeds, the parties are allocating $0 to future medicals? Is that a distinction without a difference in light of this new CMS policy, or is actually verbalizing within the release allocating $0 for future medicals? Does that run contrary to what CMS has just provided?
John, I'm going to recommend our clients be specific and say $0, no dollars have been allocated out of this amount for future medical. I want to trace that language that we saw here earlier in the body of my settlement agreement so as to make sure that we can document to CMS we follow to the letter exactly what your requirements are. So that would be my legal recommendation to folks, right? Go ahead and put the big number and then go ahead and say no dollars are being allocated for future medicals here.
It helps to connect the dots, right? Because here's the thing. After the fact, if Medicare does have an issue with this, and Medicare might, remember, just because the review policy is going away doesn't mean Medicare is not going to know about a zero, especially if we're talking about this with respect to a current Medicare beneficiary after April 4th of 2025, right? CMS, if they come knocking, the first document they're going to want from you is the settlement agreement, right? So that settlement agreement is so critically important in how it's worded, how it's drafted, and making sure that not only I's dotted, T's crossed, but it is consistent from start to finish with respect to these Medicare secondary payer and these MSA issues. Can't stress that enough.
Agree, John. Absolutely right.
I agree as well.
All right, we've got 4 questions left. Again, if you're still out there, thanks for sticking with us. I promised we'd answer all the questions. So if you've got one you've been sitting on, haven't turned it in yet, now's the time. Put it in the Q&A box for us, okay? Here comes Jonathan with the question, is it enough if the state's Workers' Compensation Act states that payment of medical or indemnity is not an admission of liability? I think we've answered that question, right, guys? Next question. Who pays the $1,000 cost of a letter from the treating doctor that no future medical expense within a reasonable degree of medical certainty?
I love it. A practitioner's question on the ground, right?
Listen, this new policy from CMS, let's be real about it. This is going to probably inject some costs into the system for a while. But ultimately, if you think about what is being taken out and removed from the system, and that is the delays of a workers' compensation settlement because of a CMS counter hire on a $0 MSA proposal based on legal rationale, right? How many weeks and months are wasted with that process ongoing only for the parties to get a counter hire at the end of the day, right? So I think at the end of the day, some short-term costs being injected into the system, but long-term, there are some efficiencies that are being gained within the system over the long haul. What do you guys think about that?
I agree.
John, this question is real because if that $1,000 cost to this letter is put in the bucket of medical expense, it may just do it, right?
Yep.
So clearly, right, the advice here is this cost is a cost, right? In other words, it is a compliance letter to the provider to merely document what the stated policy now requires. And that way it becomes, like a lot of other components to an employer carrier, an expense cost to the system, not an indemnity and not a medical benefit, so that it does not violate and it doesn't at all conflict with, right, the purpose of the original here, which is an approval, if you will, right now, or a legal opinion with regard to that zero workers' comp MSA.
And guys, again, to take that concept one step further, let's talk about timing of the categorization of it. when does that need to be done properly? Is it life of the claim before the parties are thinking about the MSA, or is there the ability after the fact to go back and maybe move it from one bucket to the other to try to fit it within the CMS parameters here?
John, if we were submitting this scenario to CMS, that moving it around doesn't smell good, right?
Right.
So our advice to our clients always has been is do it early, do it correctly. Let's talk about this scenario and what are the proper mechanisms and appropriate things to do to make sure that CMS can see from the get-go where these dollars were coming from and why we included them as an expense as compared to a benefit.
I think that should be their standard policy, to make sure that the expenses go in the expenses category, and it's not for medical treatment. It's an expense to get an answer to an important question. So it should always be an expense.
And guys, honestly, another advantage of hiring us early on in the life of a claim is that if we see that, we know, okay, let's get that corrected ASAP, because down the road, the longer that change is not made, the worse position you may be with CMS with respect to this issue.
Yeah.
So it's early identification, issue spotting, like any other good attorney on a file, right? You're issue spotting, and you are providing advice to the client about how to act and react in advance of knowing this is coming at some point. In a prior question regarding a $0 MSA for a non-Medicare beneficiary, why is it not the determining factor that the claimant is not a Medicare beneficiary? Matt Schufeld, great question. Good to see you. Thanks for joining us today. Why is it not the determining factor that the claimant's not a Medicare beneficiary?
John, you and I have been having this conversation for 20 plus years, right? And you are so good. You were the first practitioner who underlined it in red, in blue, and said, look, it says in all workers' compensation claims. Like, oh, I keep thinking that this stuff only applies to those individuals that are current Medicare beneficiaries. And John Caddy hits me like a 2x4 by saying, you better read that again right there.
Yeah, I mean, listen, apply it how you want to. If you're an attorney giving advice to your client, be cognizant of this, but Medicare in the guide has said, and now it's said it in many iterations of the guide, that claimants must consider Medicare's interest in all workers' comp cases, irrespective of beneficiary, non-beneficiary, reasonable expectation. All workers' comp cases means all workers' comp cases. Now, the reality of the situation is that, and I remember a few years back, and I wanted us to circle back to my MSA risk dartboard, if you guys remember that. At the very center of that graphic, the bullseye is always the Medicare beneficiary. So if you have a claim involving a current Medicare beneficiary, those are the highest risk cases, not only for MSAs, but for MSP. Because as we know, if a claimant's not Medicare enrolled, you don't have to worry about conditional payments. You don't have to worry about reporting anything to Medicare under the mandatory reporting provisions. All you have to worry about is this MSA issue, okay, for non-beneficiaries. Now, remember, coming in April of 25 is the mandatory MSA data reporting. And that's what makes that current Medicare beneficiary already the riskiest category with respect to this, ratchets that up another notch from a risk perspective, I think. But at the end of the day, consider Medicare's interest in all workers' comp cases, irrespective of Medicare enrollment status.
Matt, I learned the hard way. When CMS looks at this scenario, and the reason why it says all workers' compensation claims, right, is even though the claimant right now, not of age and no Social Security disability, if 6 months from now, a year from now, that disability application does commence and that claimant becomes a Medicare beneficiary, then Medicare's interest would have not been appropriately considered at time of settlement if all we took into consideration was the fact that he wasn't a Medicare beneficiary at the time of the settlement. So Medicare has seen enough cases over the years where on the date of settlement, neither of age or Social Security disability, but a year later, he becomes entitled. And now Medicare is looking back to say, what did the parties do way back then to take Medicare's future interest, fully knowing that this could have been a possibility. So that's the reason why John keeps hitting me again and again that it's all comp claims, not just those current Medicare beneficiaries.
Here we are, gentlemen, the final question. We're on the precipice. All right, under the first prong, if the treating physician states that to a reasonable degree of medical certainty, no future accident-related medical treatment or medications is required, do you see any distinction between having this in the medical treatment records or in a separate note, okay to safely set aside $0?
I do not. If
I
that
don't see a distinction either.
that statement is made in part and course of his medical records, maybe even better than a, just a lone letter that indicates that, right? If that is part and parcel of his notes and the course of care and the record that he has created, that's as valid as if not addressed and a separate letter is written, right? And oftentimes that's exactly what, in most cases happens, perfect. But part of the record or the independent letter, both I think are just perfect if that language contained here is in there.
Well, guys, we did it. We got to the end of the Q&A, the end of the presentation. Why don't we share some final parting thoughts with everybody? Jim, why don't you lead off? Any final thoughts for the participants of the webcast today to think about?
I'd be glad to. Canyon Gonzalez is very impressive from the standpoint of taking the interests of its clients into consideration in dealing with every issue that is presented. It is most strongly presented in these cases where we have the potential for a zero MSA. The facts support the fact that there should be. And so I would be very pleased to have the opportunity to help our clients go through those details and utilize the opportunity where it is appropriate to establish that so that you can move forward and get your cases resolved where it's appropriate under those circumstances by the advice that we're able to give you. So we look forward to working with you.
Thank you, Jim. Raphael, how about you? Any final thoughts for the audience today?
John, what a year 25 is turning out to be, right? Between this zero workers' comp MSA changes, you've talked about the mandatory reporting of these things, coming along. And then later on in quarter number 4, we're going to see for the first time Medicare look into its system, pick out 250 cases, and sometime first quarter of 2026, they're going to let us know whether anybody has been picked out of that bunch and civil monetary penalties coming their way, meaning they were more than a year late in reporting either ORM or terminating ORM or the TPOC, which is a component that we have been talking about here, part of this MSA component, and even the zero workers' comp MSA would be part of reporting total payment obligation to claimant through that mandatory reporting. So stay tuned. Lots of these changes, I think, are going to have big effects on the workers' comp industry. John, I think you started us off saying that, and I think that is an absolutely true statement here. 25 challenging year for all of us, so stay tuned.
As for me, I mean, the changes are coming fast and furious nowadays. And what worked 5 years ago, as far as your Medicare secondary payer, your set aside protocols, they don't work in 2025. So I would highly encourage you to review what your current protocols are in these areas, not only for MSAs, but also for conditional payments and for mandatory reporting. make sure that those protocols and the advice you're giving clients, if you're an attorney, that they're up to par with 2025 standards, because more than ever, Medicare is paying attention. They are collecting data. They're looking to institute civil money penalties against non-compliant entities. And they are paying and chasing reimbursement of conditional payments more than ever. And in these times of change politically in Washington, D.C., it seems as though the collection of data, the analysis of that data, the use of that data to increase fiscal efficiencies within the federal government has become top priority. And so this is just one example of a change that is getting made, implemented, and moving forward in order for the government to maybe become more efficient, but also lean on the data getting collected going forward to be able to monitor and impose penalties against non-compliant entities. And so the clients that work with Caddy and Gonzalez, we help to review, revise, update, and modernize their compliance protocols. We provide, of course, the traditional MSA allocations as have always been done, but one of the advantages of having a law firm and lawyers doing that kind of work at the end of the day is the ability to give legal advice. And we really think this $0 work comp MSA legal opinion is going to be a solution for those in the industry who are sad about this $0 MSA policy from CMS and are struggling for a solution and maybe lack the confidence internally to do it themselves, and maybe don't necessarily trust a standard vendor to go into the deep level of detail that maybe lawyers who practice this area, who give advice in this area, that they do. So with that, guys, I really appreciate you joining us today on our webcast, talking about $0 MSAs and what's to come, and our solution for the work comp industry. Be on the lookout. Our next program will be in approximately 3 months. And if you follow us on LinkedIn, on social media, or you get our newsletters by email, you'll see that topic in the coming weeks, and I encourage you to tune in and join us for the next edition of this webcast series. So with that, guys, let's wrap things up, call it a day, and thank everybody for their attendance.
Thank you, guys.
Thanks, everybody. Until next time.